Well, thank you, Mr. Chairman, and thanks to our witnesses for being here today, especially Professor Clark, who flew all the way from St. Louis on short notice. Mr. Chairman, I spent my recess traveling across America. I was in 10 states, including your beautiful Kentucky. And one thing I found is that all over America, people are in an uproar over the money that billionaires are spending to influence justices on the United States Supreme Court. Americans see that personal gifts to justices from right-wing billionaire sugar daddies like Harlan Crow and Federalist Society dark money expenditures are fundamentally perverting judicial ethics and undermining justice and the rule of law. Now, apparently responding to the national outcry over this ethics crisis on the court, our colleagues have called a hearing today about the influence that wealth exerts on the justice system, but they've gone off on a surprising and bizarre tangent. The problem, they say, is not the way the public is harmed when billionaires bankroll the private lives of ethically challenged Supreme Court justices. The real problem is that giant corporations are harmed when Americans injured by toxic torts or environmental crimes receive contributions from donors to help them bring personal injury or class action lawsuits. In other words, while Supreme Court justices are jetting all over the world on fancy private family vacations paid for by right-wing billionaires or collecting hefty cash gifts from those billionaires for their personal museums and family members' private school tuition payments, the GOP says the real problem in our legal system is that too many victims of corporate wrongdoing are finding access to the courts in the first place. Now, we say justice is blind because the Greek statue for justice wears a blindfold. In solving cases, justices are supposed to be blind to wealth and poverty, personal friendship, and political affiliation. A poor person who has never met a judge must be treated the same by the courts as Harlan Crow, the real estate tycoon chum of Justice and Mrs. Clarence Thomas, who had a case before the Supreme Court and who has given the Thomases lavish personal gifts like week-long luxury travel on his super yacht and private jets and generous money payments for family tuition over a period of 20 years ever since Thomas joined the court. A collector of not-so-fine art created by dictators who actually owns and displays two paintings done by Adolf Hitler, Mr. Crow donated $105,000 to the Yale Law School in 2018 for another painting he desires, writing a check to the, quote, Justice Thomas Portrait Fund. But Justice Thomas isn't unique. He's just emblematic of the collapse of legal ethics across the street. Justice Alito took a long fishing trip with a hedge fund magnate who's had business before the Supreme Court 10 times in the last 15 years. Neither justice recused himself in the relevant cases or made any relevant, timely disclosures. Justice is supposed to be blind to the blandishments of money and class power. It's only supposed to see the facts and the law, but in the Roberts Court, judicial vision is clouded everywhere by dollar signs and luxury power trips. The facts and the law are barely visible when it comes to the rights of workers trying to organize a union, or poor women seeking abortions, or consumers injured by adhesion contracts and corporate ripoffs. Justice is a rich man's game in this court of billionaires. The Bill of Rights has mostly been left in the dust. On the Roberts Court, justice is indeed blind, but only to ethics itself. It is deaf to the pleas of women and working people, and it is dumb in its refusal to see how it has destroyed its own legitimacy in the eyes of the public. It is certainly not mute, however, as Justices Alito and Thomas vociferously defend their jet-setting lifestyles in shockingly intemperate terms. If we're going to return to equal justice under law, as it's written over the entrance to the Supreme Court, if we're to make justice blind to the wealth and the identity of the parties in the courtroom, then our justices must be held to the highest ethical standards. And yet, amazingly, the justices are not even subject to the basic code of conduct for United States judges that all other federal judges are subject to. The 9 justices are, in fact, not bound by any ethical standards at all, much less the comprehensive ethics code that applies to all the other judges. Their decisions can affect or destroy the rights of all Americans, but the justices refuse to abide by any written ethical code. They decide on their own if their work is impaired by a real or apparent conflict of interest, a terrible system which cuts against the key principle of justice that Madison articulated in the Federalist Papers. No man is allowed to be a judge in his own cause, in his own case. the highest court in our land now has the lowest ethical standards. This is the crisis we should be discussing today. But our colleagues have instead called a hearing to assert that it's just too easy to haul corporations into court when they violate other Americans' rights. The third-party litigation funding under attack today is the only way that a lot of victims of corporate misconduct can even get into court. Do our colleagues really want to make it illegal now to receive contributions to vindicate your rights? I could understand if they were saying that all the present federal rules of civil procedure against frivolous, vexatious, and groundless litigation weren't working. I could understand if they were arguing that Rule 11 sanctions against baseless lawsuits needed to be expanded or fortified, but that's not what they're saying. They're not citing any kind of increase in frivolous or meritless litigation, nor are they arguing that current sanctions don't work. Those sanctions are working just fine. No, they're looking for ways to reduce the prosecution of merit-worthy and successful lawsuits against actual corporate wrongdoers. And by pulling the rug out from underneath actual tort victims, they hope to keep plaintiffs from even getting into court. The GOP wants to dramatically reduce accountability and liability for corporations that flood our country with opioids to make obscene profits, corporations that poison our communities with asbestos or lead and other dangerous carcinogens, and corporations that inflict black lung disease, mass oil spills, and other lethal injuries on American communities. Our colleagues seem confused. No one has a right to bribe judges or load them up with fancy gifts, but people do have every First Amendment due process and equal protection right to raise money to make their case in court. The courts are not just there for rich people who can write themselves a big check. This is the same reason people have a right to give and receive campaign contributions for public office, is not just for the independently wealthy. Victims bringing these lawsuits, especially those who are low income or unable to work because they're sick or injured, often cannot afford to bring the lawsuits at all without financial help from other citizens. If their lawsuits have no merit, they should be thrown out. But if they have merit, then we should all be grateful that they are working to make society safer by stopping the wrongdoers before they commit more wrongs against society. Many landmark cases establishing the basic rights of Americans have been funded by contributions from outside groups: Brown versus Board of Education, Loving versus Virginia, U.S. versus Windsor. The corporate interests represented on the panel today who are attacking this basic right are here for an obvious reason. They don't like paying damages when their victims prove their rights have been violated in court. Johnson & Johnson has had to pay billions of dollars for its central role in the opioid epidemic, and billions more to tens of thousands of people who develop cancer because of the country's dangerous talcum powder. Mining and offshore drilling companies have had to pay billions for poisoning communities' land and water and causing irreparable harm to human health. Perhaps one of the biggest environmental cases in the history of the United States, oil company BP agreed to pay $20 billion for damages caused by the Deepwater Horizon oil spill in the Gulf of Mexico. One can only regard with amazement the fact that our colleagues are in such a hurry to promote the grievances of these big tortfeasors and wrongdoers that they don't even pause to consider that there are hundreds of millions of dollars in right-wing third-party litigation financing regularly bankrolling anti-choice, anti-LGBTQ, anti-gun safety lawsuits, among many others. Well-funded right-wing networks like the Pacific Legal Foundation, the Koch Network, the Judicial Crisis Network have poured hundreds of millions into remaking America through the courts on issues ranging from attacking public school curricula to opposing compulsory union dues to repealing the Consumer Financial Protection Bureau. The Alliance Defending Freedom and other right-wing groups brought the Dobbs case and are working to eliminate access to abortion for all Americans. That's their right. Our colleagues don't complain about that. In fact, they don't even mention it. Are they willing to sacrifice the rights of their third-party litigation financiers on the right, or are they just not serious about this whole thing and simply looking for another catchy way to distract everyone from Donald Trump's 91 different criminal charges in 4 indictments across the land? Everyone knows that a fish rots from the head down, and everyone knows what stinks to the high heavens in the judicial system today is, alas, the Supreme Court itself. Let's focus on where the corruption of justice is actually taking place today. Thank you, Mr. Chairman, and I yield back.
Gentleman yields back, and I want to